a closing plenary entitled Confronting Our History, the Role of Race in the Criminal Legal System. We have a dynamic panel this afternoon to discuss this most important topic, and I'm going to give them an ever so brief introduction. First, I will introduce Mr. Jeffrey Robinson, author, activist, lawyer, hero. He's currently with the ACLU in New York. He's an author of Who Are We? A Chronicle of Racism in America. Next, I will introduce Ms. Barbara Creel, professor. She is on the faculty at the University of New Mexico. She has expertise in Indian County criminal defense. She is active in the American Bar Association and is a member of the Women in Criminal Justice Task Force. I would next introduce Mr. Ian Main, who is faculty with the University of Wisconsin. He also is a prolific writer and speaker. He is also the reporter for one of the criminal justice standards and very active, and has written a paper about the origins of the civil and criminal rules. And you may hear some of that today. Next, we have Professor Angela Davis, a distinguished professor of law at George Washington University. She's the author of Arbitrary Justice, the Power of the American Prosecutor. She's also an editor of the work Policing the Black Man, Arrest, Prosecution, and Imprisonment. And finally, we have the Honorable Judge Carlton Reeves, who is in the Southern District of Mississippi. Judge Reeves is a powerful judge who has really decided cases that have become templates for sentencing. He has spoken eloquently on all manner of topics. He's written seminal cases on qualified immunity. He is a judge who embraces the rule of law, but also speaks truth to precedent, power, and history. This is our panel this afternoon, and I want to get started, first of all, by going to Jeff Robinson, who has talked a lot about the role of race, and he's talked about some of the language of the 13th Amendment that supposedly freed the slaves, but he talks about some of the defects or weaknesses in that language and looks at how that plays out today in where we are in our racial history. I invite you to hear Attorney Jeffrey Robinson. Mr. Robinson.
Thank you very much, Judge Donald, for the incredibly gracious introduction and for chairing this panel on a topic that is about as significant as anyone in the country today. And I think in terms of understanding the criminal legal system and how race has impacted it, we can go to the Constitution and the prelude to that. Because many people think, well, there was a difference, or was there a difference between colonial America and constitutional America? What led up to the Constitution were a series of rules, of laws that were enacted in different states to protect white supremacy. I'll use Virginia as an example. In 1662, they passed a law saying if a mother an enslaved mother has a child, that child is enslaved. Why would they pass that law? Because white men were raping the black women that they owned, and the law wanted to be clear. If those children come out with blue eyes or freckles, don't go thinking that's a human being. That's an enslaved human being. So there we see that the law decriminalized the act of rape when white men committed it against black women, and also characterized the result of that rape as an enslaved person. The other law that I think really leads up to the Constitution And it's remarkable. In 1669, Virginia passed a law saying if an enslaved person was killed while resisting a master, that act was not a felony. I don't claim that law is on the books of any state in the country, but I will tell you this. Look at the number of black people that have been killed, unarmed black people that have been killed by police in America in the past 10 years. Compare that number to the number of police that have been prosecuted for the killings. Compare that number to the number of police who have been convicted of anything. That law may not be on the book, but if you substitute law enforcement officer for master and black American for enslaved person, it's still in effect. Let's get to the Constitution, because that is the founding document of our country. And if we were going to go in another direction, then that was the place where we were going to do it. But Judge Donald, what ended up happening is America doubled down on all of the slave statutes that had been enacted by the colonies. We're talking about the 3/5 rule. We're talking about preventing any state from passing a law restricting bringing enslaved people from Africa into the United States until 1808. And then at the end of the Constitution, they even doubled down on that and said, well, somebody might try and amend the Constitution that prevents states from passing that law. So we'll add an article that says you can't amend that article until 1808. They just doubled down on this stuff. The word slavery appears once in the Constitution because the South didn't like the word, and so the North didn't use it. Words like, or phrases like such persons were substituted in the Constitution until the 13th Amendment. And what it said is neither slavery nor involuntary servitude, except as punishment for a crime, shall exist in the United States. And that word except drew a huge, huge gap in pre-slavery America and post-slavery America, because it was a way to impose slavery by simply convicting someone of a crime. And as we go forward from the Constitution, I think one of the things that we also find in there that plays such a critical role is the creation of the Electoral College. 3/5 rule. Black Americans counted as 3/5. One of the things that everyone will remember, Give Me Liberty or Give Me Death, Patrick Henry. One of the letters he wrote to the Constitutional Convention said, there are 236,000 enslaved blacks in Virginia, and there are few or none in the northern states. Now, what he was worried about was getting guns to keep them under control, but multiply 236,000 by 3/5, and you get a huge number that is added to the calculation of how many Congress people you get and how many votes in the Electoral College. The Electoral College was created to ensure the South that it would have significant say on who was president of the United States. And if you want to know if it worked or not, 7 of the first 12 presidents were from Virginia, and 2 others were for southern states. So 9 of the first 12 presidents of the United States were from the South. And I say that because the Electoral College and the manipulation of black bodies in terms of who could vote and who couldn't and who would ultimately control the country came into play in another critical area. And I'll just tell you about it really quickly. If you think we're in a show right now with the Electoral College, go back to the presidential election of 1876. The final Electoral College vote, 185 for Rutherford Hayes and 184 for Samuel Tilden. How did they get to that? They had to have a commission come in and broker a deal. And the third element of that deal was remove the troops from the South. And what happened then was that the South basically started to pass laws that essentially criminalized Black life. 90% of the people forced into convict leasing arrangements were Black. Alabama's non-white prison population jumped from 2% in 1850 to 74% in 1870. They're passing laws saying that stealing a chicken is a felony. And you also have states that then start to pass felony disenfranchisement laws so that people's right to vote is taken away when they're convicted by a crime. And the pattern is absolutely clear. Look at the states that had large Black prison populations. They extended felony disenfranchisement laws or enacted them. And when you look at the states that had small Black prison populations, they either eliminated felony disenfranchisement laws or narrowed them. This was just a way that the law was criminalizing Black life and preventing Black Americans from fully participating as citizens. And as you think about it, I just want to make a couple of last comparisons to make this point. Because when people think about Jim Crow laws, Black codes, separate but equal. Mr. Plessy got arrested on the train in New Orleans because he went into the white section. It's the police that are enforcing those laws. The police and the criminal justice system are stepping in and saying, get to the back of the train, get to the back of the bus, enforcing redlining. And so all of those things that were roadblocks to essentially Black freedom in this country, somebody had to enforce them. And this is the last example that I will use to kind of bring us some thought here. Between 1865 and 1950, Bryan Stevenson's organization has documented over 6,000 racial terror lynchings. That means that for 85 years after the Civil War, America was lynching, on average, one Black person every week. Look at the history books and try and find prosecutions for those lynchings. You can find photographs of them with all kinds of people watching because nobody was afraid of being arrested. So when you think about the criminal justice system in America, we have to think about not only what the police did, but what they did not do in terms of protecting certain Americans. And here's where I will end. After that statistic, which every time I say it, it blows my mind. One Black person every week for 85 years after the Civil War. And 4 days ago, on November 16, I wake up to the 2019 FBI hate crime report. For 2019, more than 7,300 total incidents, 51 murders, 30 sexual assaults, 3 human trafficking offenses, and 41 other hate crime categories. And so what that means is that in 2019, 155 years, 154 years after the Civil War, when it comes to hate crimes in America, we were having 1 murder and 140 other hate crimes every week. This is the foundation of the criminal legal system that has brought us to where we are today. Thank you.
Wow. You know, Jeff, you mentioned about the lynchings and the lack of prosecutions. And as I was saying earlier, I wrote a thesis about the rule of law, when the rule of law breaks down, and looking at some of the massacres that occurred right after the Civil War, but looking at some of the terror and using the Memphis example as one. When talking about the lynchings here in Memphis, and maybe Judge Reeves can talk about Mississippi, but you know, oftentimes when there was a lynching of an African American person, it was a community event where people packed picnic baskets and brought children, and of course there were not going to be any criminal consequences because people just sort of celebrate this. Okay, we're gonna lynch another person, and people watched, and that was entertainment almost.
Well, Judge Donald, I think that is part of the thing about understanding where this fits into our our evaluation of the American criminal legal system. You can't lynch someone in the middle of town without the police knowing about it. You can't take pictures at the lynching, put them on postcards, and mail them all over America without law enforcement seeing it. So law enforcement was either directly involved in these lynchings, or they were passive participants who stood by with their arms crossed and let it happen. And when you ask, why is there so much mistrust in the Black community and the criminal legal system? My answer is, go back to the beginning of the colonies in this country and you see example after example after example. How could it be otherwise?
Well, in the 1866 Memphis massacre, the police were definitely involved. The judges were involved. The newspapers were involved. And all of this was something that fueled that. But I'm not a panelist, but this was incredible. You know, and you talked about dehumanization. I want to go to Barbara Creel, because there has been huge dehumanization with the Indigenous Native population. Today, we're seeing some of the remnants of that. And Barbara, could you talk with us about how race has played a role with respect to the lives and development and the history of Native Americans? And Judge Reese, I know I called your name before, but then I didn't call on you, so I'll come back though. Thank you. Barbara?
Thank you, Judge Donald. And first I want to start by saying thank you to my grandfathers and my grandmothers for passing down their love and support to my parents and my family, and all of the community support that I've received from my tribal community and others that bring me here today. I also want to thank Judge Donald for this incredible invitation and opportunity to talk about Native Americans and confronting our race. And thank you to the other panelist members on this illustrious panel. A reminder that wherever you are, I hope that you are safe and well, and some people, like people in our tribal communities, are being affected by the COVID-19 pandemic in very different ways than other people. And wherever you are, I hope you're safe, and remember that you are on Native land. This is land occupied by our ancestors pre-European contact and pre-settler colonialism. But confronting our history is confronting our histories, that there are many different ways that Native people have been impacted, and it depends on their geographic location and the intent of the laws that were imposed upon them. So there are over 570 federally recognized Indian tribes, countless more that were terminated or decimated or simply forgotten about. And so it's important for us to remember that in confronting our racist background and history as a United States, that it hasn't included the Native voice. It is a history written largely without adequate input from the Native peoples and our connection to this land from time immemorial. And the fact that Natives haven't been taken into account or adequately, our voices haven't been adequately included, has been impactful. And you can draw a direct line from the beginning of the United States and the Founding Fathers' decision under the Constitution, and where we are today with the negative statistics that impact Native people, whether it be during this pandemic or the over-incarceration of Native peoples. But when I talk about Native Americans in the criminal justice system, I implore my fellow attorneys and federal defenders to combat willful ignorance about Native peoples. I say you've come by this innocently, or at least honestly, because Native people's voices weren't included in your preschool other than the first Thanksgiving, or they weren't included in your elementary school or high school AP histories unless you read a book written by a white person about a Native person. And we're certainly not included in higher education unless you are studying separately the idea of ethnic studies. And so combating willful ignorance is a good start, but we also have to remember that this was intentional, that this is not just an oversight of Native Americans, that there was actually a concept called the vanishing Indian that allowed the Native narrative to be displaced or replaced with the white narrative of Native peoples. And we can see this in our federal court system. The studies and the research that I have been doing with my research assistant, Krista Thompson, who is a citizen of the Navajo Nation, has really shown us the destructive power of language. But this vanishing Indian concept was an idea that Native peoples, by design, would dissipate, would be disappear into the fabric of the American frontier. And they were kept alive by these media images, either in movies or written word, that encompassed both visibility, invisibility, and hyper visibility. Invisibility in that they were in the land to the west. They were the noble savage. Natives were communities that were distinct and on their own and separate from the United States. There was a romantic ideal captured by photographers and artists who went west and captured the image, because eventually Western civilization and manifest destiny meant that there would be a United States of America from sea to shining sea, from the east and to the west. These stories about Native Americans continued, and the vanishing Indian is often seen in an artistic depiction of a native on a horse with the horse hanging his head. It's a sculpture entitled "The End of the Trail," the dejected Native American that either becomes irrelevant or is honored in his death. These concepts weren't just in artistry or the media. They were designed by people called the Friends of the Indian that created policies and then brought them to Congress. They were created by the Bureau of Indian Affairs that was under the War Department until the mid-1800s. They were created by the heads of the Bureau of Indian Affairs that created a court of Indian offenses that criminalized the behavior of being Indian, that criminalized using your native language, dancing in ceremonies, and took away native practices and supplanted them with Judeo-Christian ideas of moralism. These courts of Indian offenses were designed not under Article 3. They weren't part of state courts. They weren't part of any federal courts. But instead, they were the brainchild of the head of the Bureau of Indian Affairs that decided that that this concept of killing the Indian and saving the man. And Native Americans were brought before these judges. There were often white Indian agents or other Native Americans who were paid to be an Indian agent on the reservation and subjected to jail time without any defense, or their rations were taken away, or both. fined a certain amount of rations and subjected to jail. And these courts of Indian offenses made sure that Native people didn't have any defense. No attorneys were allowed. That was a law on the books in the courts of Indian offenses. No right to an attorney. Attorneys are prohibited. That law stayed on the books until the Congress considered Indian civil rights under the U.S. Constitution, and it wasn't removed until the 1960s. That legacy of no defense for being Indian can be seen as a direct line to Native Americans in federal court. Native Americans are subjected to the Major Crimes Act, which is a racist federal law that brings and hauls Native Americans off the reservation to be prosecuted in federal court and subjected to the federal sentencing guidelines because of this idea from the 1800s that Natives didn't have laws and justice, and that the United States needed to subject Indians to a civilized court system where they could face the civilized punishment of death. The case where Native voice was heard was a case called Ex parte Crow Dog, in which Crow Dog, a Brule Sioux tribal member, was charged in federal court for killing Spotted Tail, another Indian agent and an Indian of the Brule Sioux tribal community. Crow Dog was punished under the local tribal traditional justice system, what we would call in the white world as restorative justice, as justice that brought him back into the community after he met with elders in the community, and his punishment was restoring the family of Spotted Tail where they would have been missing their family member. So he was ordered to provide blankets, horses, and money for the family. Because he was already punished under the local traditional system of justice, the federal court found that under the treaties and statutes at the time, he could not be hauled into federal court and subject to the death penalty. And in writing that decision, the federal court opinion telegraphed to Congress that if there was jurisdiction, that jurisdiction would come from Congress under their power and oversight over the Indian nations. Immediately after that, Congress passed the Major Crimes Act of 1885, and Native Americans have been subjected to criminal prosecution, conviction under the federal court system ever since. And these decisions have led to many impacts on Native Americans, including this idea of language that's encapsulated in federal court decisions, including words such as superiors of a different race, that the white people are overseeing Native Americans who have a savage nature, who are, quote, warlike, quote, barbarous, quote, primitive, crude, and uninformed, that Native Americans needed to be subjected to a civilized form of justice, like the courts of Indian offenses or the federal courts. Well, this continuation of the right to counsel denial has even been upheld as recently as in 2016, when Justice Ginsburg issued a decision in United States versus Bryant and found that a Native American subjected to his own tribal court without counsel, those convictions could be used against him for a federal domestic violence charge. And so even the people that we uphold as bastions of equal justice and access to justice for all have a disappointing view of Native Americans, that they are people that need to be punished, and not just punished, but punished more harshly, and punished in a system that will actually see them as who they are, the savages who should have been joining civilization going forward. My writing and my scholarship has been devoted to representing Native Americans in these supplanted adversary systems that are tribal courts, that are under-resourced courts. Under the Indian Civil Rights Act, Native Americans can go to jail under this federal law without counsel up to a year. They're also subjected to double jeopardy, meaning they can be prosecuted both in tribal court under a traditional system and prosecuted in federal court. Native Americans are seen often in negative statistics, such as being defendants and victims at percentages far above our presence in the United States population. They're also seen in the lists of missing and murdered Indigenous women. And I say because this blind justice, this invisibility of Native Americans, and this lack of defense counsel that has been developed underdeveloped under the law, has led to this position. But I also want to end by saying that Natives are so much more than those negative statistics. And at times, Native Americans are left to be the people that need to solve these problems, because no one else understands them, or no one else is endeavoring to address the solutions. In my courses, I teach my students, whoever they are, that they have a role in understanding Native Americans, our racist history, racist criminal justice system, and they have a responsibility as lawyers to become part of the solution, and to see Natives as so much more than the negative statistics, that we have a resilience that reverberates, and an Indigenous wisdom that needs to be accounted for and celebrated. Thank you.
Thank you, Barbara, for giving us that rich history of Native Americans, America's first people. Let me just say this. For those of you who are listening, we will certainly have time for questions and conversation. If you have a question, you can start putting those in the question box now. And we will, after we have gone through the initial presentation of all of our speakers, we'll start some dialogues by and between the panel, and also address your questions. Professor Ian Main from the University of Wisconsin certainly has looked at our rules, and he's written a paper called Civil and Criminal Procedure are so different. And then he asks the question, why, and goes into the forgotten history. I want to turn to him now to talk about how the rules have played a role or reflect this role of race in the criminal legal system. Professor Main.
Thank you so much, Judge Donald. I so appreciate it in that introduction, and I've already found the presentation so far on this panel unbelievably powerful. And I hope to add to the story, and in many respects, the lost story. Part of, for example, procedure and race. Part of this story begins with me kind of being brought up as a civil litigator, and then 6 or 7 years into my experience as a civil litigator, being mentored by blessed to be mentored by extremely good litigators, being in court a lot, and transferring over to be a public defender. And when I first walked into the court as a defense attorney for an indigent person, I didn't recognize the courtroom that I was in anymore. I had been in a type of courtroom for 7 years, and now I was in a different courtroom. And I came in with entitlements. I came in with expectations. I came in with what kind of information I need to have in order to defend my client. I came in with lots of expectations that no longer had any footing at all. And so I'm going to share my screen with you now, if you don't mind. And so one thing that I started thinking about a lot was, what's a courtroom? And the fact that the courtroom, if the civil calendar was going on in the morning and the same judge was in their afternoon, but then looking at the criminal calendar, despite being in the same courtroom, despite having the same judge, there were two separate courtrooms, and they were unequal, and they were separate, and they have nothing to do with each other. And that just didn't make sense to me. And clearly, as a civil litigator, I thought the justice that was being handed out on the criminal side, to the extent you can use that word, was inferior in every respect. You know, as I started thinking about these differences, one of my colleagues said, well, there has to be a good reason for this. And I realized we hadn't gone to the origin story. And the origin story starts actually in 1935 when the federal government decided to reform procedure. And that was the civil rules that we're all familiar with. They created, and it was intended to and did shape state procedures, transferring from a common law approach to procedure, which had shared a very deep parallel structure between both the criminal and civil proceedings. They were very, very similar. I found and then it was just a couple years later, in 1938, that was passed by Congress, and immediately, because the reception for the civil rules were so positive, then there was a movement, and it was expected anyway, that the federal reform would also apply to criminal rules. And so Congress asked the Supreme Court to appoint another committee and to create these criminal rules. I was able to get, there's only one copy in existence in the United States. I was able to get the original set of rules that was proposed for the federal rules of criminal procedure. It was in Harvard. They let me look at it. I opened it up, and it was confidential in the sense that it had been produced under confidentiality. The public had not seen it. And when I looked at it, I was struck. What I saw were the rules of civil procedure, minus summary judgment. But I saw the rules of civil procedure. And I found out that in a meeting of the full committee, within 3 days, a drastically different template emerged. And this different template that emerged then shaped and influenced state reform as expected, as intended. This was the first. This was what criminal procedure looked like in September of 1941. It was a unified approach to procedure. There would not be separate and unequal courtrooms had this been passed in terms of, not resources, and other social aspects that are, of course, part of the criminal system. But there would be agency for the defendant to be part of the investigation, to be part of the litigation. Over 3 days, this is what we ended up with. The entire discovery phase in 3 days was erased. The idea that the judge would be involved with pretrial conferences was erased. The idea that there would be a written, deliberative, transparent process of deliberating over legal and factual issues was erased. Only left was notice pleading, which actually eased the prosecutor's path into the courtroom without a judge being a gatekeeper, which was part of the common law, and allowed the prosecutor to stack claims, which was also a different feature than was there in the common law. Both of these things, notice pleading and joinder, was taken from the civil template. It wasn't criminal in nature, it was taken. These were innovations taken from the civil procedure. So we started like so, and then visually we ended like so, where in the civil procedure all litigants had agency, but in the criminal procedure only the prosecutor had agency. This happened in 1941, and it occurred to me is there something unique about this timing? No one ever asked this particular question, which is, does it matter that this reform occurred at the height of Jim Crow? And just asking the question, I think, has profound repercussions for the ad hoc current justifications for this system. First, you need to account for the fact that this emerged from Jim Crow, and it has not changed since. I love this quote by James Baldwin, that history doesn't refer to the past, but it's constitutive of the present. In fact, we can't separate it out from the present, that it absolutely shapes our frame of reference and how we view the present and the future. And so what were these historical dynamics and entrenched norms that influenced these 18 white men who were coming up with the rules of criminal procedure? What social dynamics were surrounding those committee, and political dynamics and tensions and requirements were surrounding those 18 white men who were drafting and created the template that we still use to determine our cases? And if we look, and this really ties into Jeffrey Robinson's wonderful presentation in terms of how the criminal system basically was constitutive of maintaining racial hierarchy after the quote-unquote emancipation, after the Civil War, and that the benefits of white supremacy were still demanded by the white population, and that the 13th Amendment obviously was used to provide the exploitation of black labor and black bodies for industrial concerns up till 1935 through that exception through the 13th Amendment that Jeffrey Robertson talked about. And by the 1930s, because the criminal system was so central to maintaining racial privileges of whites, as Kahil Muhammad writes, blackness stood as a singular mark of a criminal by 1930. It's also important to think about what the world looked like then. White attorneys were found in the courtroom, really no one else. In 1936, 4 black law students graduated in the nation. At the same time in Alabama, there were 1,600 black preachers. There were 4 attorneys in the entire state who were African American. This was a white world. In civil litigation, despite the fact that there was a CRA of 1875 that allowed black individuals to bring civil cases, it didn't happen. And in fact, in the South, 99.5% of the civil litigation was done by whites, despite the fact that right after the Civil War, 90% of the black population was in the South. Despite their Herculean and very brave attempts to bring civil cases, the surrounding social resistance and hostility and the kind of hostility they would find in the court closed the courtroom door for all intents and purposes. Civil litigation was a white world. Criminal litigation was where you'd find a black litigant. You'd find white litigants as well. Published by the drafting committee of the federal criminal rules, it was expressed to the public and the bar associations that were reviewing these rules that most defendants in the South were black, and certainly there was a massive overrepresentation of black criminal defendants in the North. And the litigation norms then were that black persons were barred from giving evidence, that they couldn't judge evidence, and that whites had the sole claim of credibility and to credibility. And in fact, whites at the time viewed this as a burden on them versus discrimination. And this comes from a quote from, again, published by the drafting committee of the criminal rules. It is an Augean task for Augean, I don't know what that word meant, but it turns out to mean so much effort to solve as to seem impossible for the white lawyer to obtain from black defendants a clear account of the facts in the criminal transaction. Now, of course, many of you are familiar with the CRA and, say, Strawder versus West Virginia and all these rules that you can't be racially explicit about making an ineligible black person to, say, be on the jury or vote. And the way that was dealt with was to create systems where there was a white gatekeeper who, with unreviewable discretion, made sure that black people, however eligible, would never serve on the jury, or black people eligible to vote would never be able to vote. And criminal procedure can be looked through the same lens, that criminal procedure gave unreviewable discretion to a white gatekeeper. And so that procedure permitted the prosecutor to determine and to be responsive to those entrenched norms, to determine what kind of charges were brought against who, what kind of facts were credited, and what kind of evidence was given to the defendant depending on the entrenched norms of society at the time. If we look at what criminal procedure looks like and civil procedure looked like in 1941, civil litigants have discretion and power. Prosecutors had police powers to get in information. Criminal defendants have no pretrial discovery powers to compel. If you look at the picture in 2020, all you do is change the date, and that's it. There's absolutely no difference now. There is zero difference now. We have the same structure that was created in Jim Crow. I contend we wrote procedure into race in 1941, and we still follow that same template. And the emerging data, of course, we already know this, is that still prosecutors are treating black defendants disparately, as our police. As Jeffrey Robinson says, it starts with the police. Every aspect of the system continues with unreviewable discretion to sort on the basis of race without the kind of transparency or the agency given to criminal defendants to actually push back. So appreciate your time and look forward from the rest of the panel. Thank you.
Thank you very much, Professor Main. That was a wonderful presentation and lead into our next speaker. You know, I introduced Professor Angela Davis earlier as a distinguished professor, and I put her at George Washington. She is a distinguished professor, but she is at American University. And I apologize, Professor Davis. I do that to you often, and I don't know why that is. But, you know, we talked about this sorting and the power and the agency that the prosecutors have. And I want you to talk to us some about the role that prosecutors have played and in influencing these dynamics of racial inequality and over-representation and over-incarceration in the justice system. And I want everybody to be able to hear you, so I'm going to ask all of the speakers to please mute your screens, as I'm going to do, and I want to turn it over to Professor Davis.
Thank you, Judge Donald, and no worries about that at all. I'm just glad you made the correction, not because I'm because my dean would be horrified that you would place me at our rival school, GW. So thank you for making that correction for that reason alone. And thank you so much for inviting me to be a part of this amazing panel. I so look forward to hearing from Judge Reeves, and I really appreciate the presentations already given by my fellow panelists, Ian, Barbara, and Jeff, who so eloquently laid out the history. I do want to talk about prosecutors. I want to talk about kind of where we are now and the role that prosecutors play in all of this. With 2.2 million people in our prisons and jails, and with the severe, harsh, unwarranted racial disparities we have in our criminal legal system at every step of the process, from arrest through sentencing. I do not think it's an exaggeration to say that we are in a state of crisis, and we have been for some time. Black and brown people are treated worse than their similarly situated white counterparts at every step of the process, from arrest through sentencing. And that's whether they're charged with a crime or they are a victim of a crime. And there are a lot of really complicated reasons for these racial disparities, but it is absolutely true that discretionary decision-making by officials in the criminal legal system plays a huge role. So when cops racially profile, they contribute to these unwarranted racial disparities. When judges give harsher sentences to Black and brown people than to white people who are similarly situated, they contribute to these racial disparities. And when prosecutors make harsher, more punitive charging and plea bargaining decisions in cases involving Black and brown people than in cases involving white people, they too contribute to these unwarranted racial disparities. But I focus a lot, although they all contribute to it, I focus on prosecutors for a reason. Prosecutors are the most powerful officials in our criminal legal system, bar none. Yes, police officers have an incredible amount of power and discretion on the street to stop and frisk and arrest people, and oftentimes tragically kill people, as we've seen, well, throughout history, from the time of slavery up to tragically this year, which has been just horrific. But in the vast majority of cases, police officers only have the power to bring the person to the courthouse door. It is the prosecutor who decides whether that individual will stay in the system and what happens to them. Because I don't have to tell this audience, you know all too well. Prosecutors and prosecutors alone decide whether a person is going to be charged with a crime and what that crime is going to be. Prosecutors and prosecutors alone decide whether there's going to be a plea bargain and decide what that plea bargain is going to be. And when they make those decisions in ways that create these disparities, they really do contribute to this problem. When you consider the fact that 95 to 98% of all criminal cases are resolved by way of a guilty plea, you can see why I say through their charging and plea bargaining decisions, which, by the way, are made behind closed doors with no transparency, you can see why I say that they control this system with very little accountability, right? So when the assistant prosecutor makes these charging decisions, they're accountable to no one but their boss, who at least on the state and local level, where 90% of all criminal cases are resolved, is an elected official in a severely flawed electoral system that really does not hold prosecutors accountable, which I'd love to talk about if we have some time to do that. But prosecutors, when they make these decisions, I'm not saying that they are intentionally saying, I'm going to pick out Black people and lock them up longer, or I'm going to treat Black victims harsher. I don't think that. We all know about, I think most people in this audience know about implicit bias. All of us, myself included, defense attorneys, judges, prosecutors, everybody in the system and in the world suffers from implicit bias. And prosecutors do too. So, when a prosecutor gets a case involving a white defendant, in the rare case time that happens, let's say it's a white kid who sold some drugs at their high school, and their attorney comes to the prosecutor and says, please don't ruin Todd's life because he is a smart kid and he's on his way to college and he's a good kid, but he's got a drug problem and he was selling drugs just to feed his habit. And no worries, because his parents are going to put him in this great drug program that's going to fix his life. And so please don't ruin his life. Let him get through this program. If he finishes it, completes it successfully, please dismiss this case. And the prosecutor looks at him and says, well, I don't want to ruin this kid's life. And he's looking at his kid. And remember, I used to do a few drugs myself when I was coming up. And somebody gave me a chance. So I don't want to ruin this kid's life. Sure, I'll give him that chance. And I personally think, that's a fair thing to do in this criminal legal system, where we don't need to be putting more people in prison, especially if they got a drug problem. But along comes Jamal with his overworked public defender. And he says, Jamal's got a drug problem. He was just selling drugs to feed his habit. And Jamal probably has maybe an arrest, but not a conviction, probably because of racial profiling. And he doesn't have a drug program, and he can't afford to get in the drug program. Give him a chance. And the prosecutor looks at him and doesn't quite have the same empathy. You know, he doesn't really see himself in Jamal. And on top of that, you know, he's like, well, what am I going to do? You don't have a drug program. So, you know, I'm just going to charge this mandatory minimum. And there you go. I mean, it's a simplistic example, but it counts the kind of thing that happens every day. I don't think it's conscious, but it happens. Does that make the prosecutor racist? No. Does it make the prosecutor responsible? Yes. Yes, it does. And I don't think it's just about implicit bias, too. I think that there are factors that we here at the American Bar Association want prosecutors to take into consideration when making these decisions that have racial impacts. So the American Bar Association standards for the prosecution function. I worked on the committee that wrote an early version of them. I believe in them. They're great factors. But guess what? Those factors can also, when taken into account legitimately, can produce these unwarranted racial disparities. For example, some of those factors we want prosecutors to take into account, like the seriousness of the offense, the likelihood of conviction, the interest of the victim in prosecution. All of those factors can have a racial impact. And in the interest of time, I'll just give one example. Let's say the likelihood of conviction. We don't want prosecutors to bring charges if it's not likely that there's going to be a conviction. That wouldn't be fair. It's waste time, it wastes money. It's not fair, right? But how do they make that decision? Well, one way they make the decision is the witnesses, right? So let's say the victim of this case that the prosecutor is looking at is, you know, a young African-American man who's been the victim of a violent crime. He comes in to meet with the prosecutor for a witness conference. He's not well-dressed. He's not articulate. He can't really tell his story very well. He doesn't make a good witness, right? And so the prosecutor's like, I'm not likely not going to get a conviction with this guy as my witness. I'm going to just dismiss his case. Right? So he's not getting the same justice that another victim who comes in polished and all of that. Does it make the prosecutor intentionally racist? No. But does it produce an unwarranted racial disparity in terms of how that victims are treated? Yes. So I give these simple examples to show that prosecutors contribute to this problem. And they are responsible, right? Largely responsible because they're so powerful and they have the power and discretion to make these decisions. And, you know, to whom much is, I'll quote the Bible, I'm not that religious, but one of my favorite Bible verses is, to whom much is given, much is expected. You have all this power, so there are high expectations. And prosecutors are ministers of justice, right? That's what they're supposed to be, right? The defense attorney's role is not to seek justice. The defense attorney's role is to zealously represent her client. The prosecutor's role is to seek justice. And the prosecutor, you know, according to the United States Supreme Court in Berger versus United States, it's not their role to seek convictions, it's their role to seek justice. Seeking justice sometimes means seeking convictions, sometimes it means not charging at all. And prosecutors don't represent victims. They represent the entire community, which includes victims, which includes the entire community. And guess what? It also includes the defendant, the accused. And so the decisions that prosecutors make, I want prosecutors to think about their role that way. We're in an adversarial system, but remember that you're a minister of justice that is responsible for everyone in the system. And so I'll just close by saying that prosecutors have a responsibility we all have a responsibility to fix this problem, but because prosecutors are largely responsible for it and the most powerful, I think they have a extra special responsibility. And I think there's some good news. There is a small but growing movement of so-called progressive prosecutors. And if you heard the breakout session yesterday, which was phenomenal, some of them have spoken at this meeting already. And that session yesterday was phenomenal. And they're doing great work. They are running on a platform of ending mass incarceration and ending racial disparities. And they are making decisions that are moving in that direction. But I think what has to happen is that in order for prosecutors to do their part, and we all have a part, to do their part, they have to center race in their decision making. And so I'm proud to say that there's an amazing initiative called Motion for Justice that is sponsored by the Vera Institute and led by Jami Hodge, who spoke on that panel yesterday and who is serving as an advisor to the council this year, and also runs the Reshaping Prosecution program at Vera. And it has set forth some amazing action steps that prosecutors can take to center race in their decision making and take some steps towards solving this horrible scourge that we have on our criminal legal system, which is the unwarranted racial disparities. And I hope maybe if there's time later, I can perhaps talk a bit more about that. But I'll end here, and so we can hear from Judge Reeves. Thank you, Judge Donald. Judge Donald, I think you're on mute.
Thank you so much. Sorry, Judge Reeves. What I said before was thank you, Professor Davis. That was really provocative and interesting, and we do need to talk about it some more. Judge Reeves, you have been a judge who has really sort of led the way in using this history to teach, to hold accountability, and to really show judges really the power of confronting issues with truth from that history. And I want to come to you to talk about the judicial system and whatever else you want to talk about. As we're saying in the Baptist Church, I want you to come to us in your own way. But I also want to lay before you one of the questions, and you can integrate it in however you wish, and other people can talk about it later. The question is from a student. He said, Aristotle said that good law does not consist in laying down good laws if they are not obeyed. Today, we have laws that prohibit racial discrimination, but those laws are clearly not obeyed everywhere. So what more can the legal system and we as lawyers do? How do we encourage people to obey the laws so that they are, quote, good? Will simply enforcing laws make people obey them more? So I put that out there, but I want you to just come to us in your own way. And if you feel, you want to talk about that, have at it. Judge Reeves.
All right. Thank you, Judge Donald. I'm just so proud to be on the group with all these phenomenal people. And for the attendees there, I think you should wrap up what they've already said in a bow and go on about your business. I've learned a lot since listening to them as we prepared for this session with you. The first thing that I would say to start with Professor Davis left off about the power of the prosecutor and the enormous, and I've come to learn after being on the bench, after having served at the U.S. Attorney's Office on the civil side, but after having come to the bench and having sat on that podium where I sit, I have definitely learned that the prosecutor is the most powerful person in the criminal justice system, because that prosecutor does determine what pleas might be offered, if they'll allow that first-time offender or second-time offender or even third-time offender to get the benefit of a pretrial diversion program, as opposed to a mandatory minimum plea to a charge that would result in a mandatory minimum prison sentence. So as I think about those who are in attendance here, I do tell my jurors, though, that ultimately when the case comes to them, they are the most powerful person during the course of a trial. Now, again, Professor Davis has pointed out that's less than 1% of the cases. The other, by and large, the other 95, 96, 97, 98% of the cases result in guilty pleas. So, but that 1% of the cases that do come to trial, the jurors have that phenomenal power. And for you lawyers who are called to talk to these church audiences, these school groups, and everything else, please make it a part of your presentation. No matter if they got you talking about family law or whatever it is. On these presentations, you encourage your co-citizens to take part, to never turn down the opportunity to participate on juries, and because your service on that jury is a phenomenal responsibility, and they bring to that jury service everything that others might not see, and you become the most powerful person. America at this time, and I'm still some of the words from John Bon Jovi, person I didn't listen to growing up. I know they had songs and stuff, but recently he has this song, American Reckoning, which he wrote and produced and sings after the George Floyd incident. Is this a moment or is this a movement? Here he talks about I can't breathe. I want you all to Google it. If you've already bought it, I know some people use it, whatever things you use, but listen to the words, listen to the lyrics, listen to the music, listen to the heartfelt response that he writes about American Reckoning. He says America is on fire, and it is, because he describes and he talks about what we all saw for that 8 minutes and 46 seconds. It's the George Floyd incident brought to life what Jeffrey Robertson has been talking about for decades. Mm-hmm. What all of us have lived, what it brought to light, what Professor Creel and others, what we have seen and been saying. It brought it to life on all of our computers, on our big screen televisions, and it captivated us because we said, how could this happen in the America that we know, in the America that we love? How could one snuff out the life of someone so casually before the seeing, the hearing, the observing public, when the public is saying, I see what you're doing? And in response to that, there was no change. I don't care what you see. I can do this. I can do this. That's what Eric Garner was saying. That's what so many others were saying. That's what Tamir Rice was playing out when he was on that gazebo out there in that park. He was playing imaginary things in his mind. I'm playing a game with myself because I have no friend to come out with me on this cool morning, this cool afternoon, this cool evening. And to have someone to call the police to say that this child might be out there waving a gun, and the officer's immediate response is to drive up to the scene and not ask one question of this child, not say one thing to this child, and that the immediate reaction is to take down that child. So you ask the question that was asked, we have these laws. We have these things. We have to make sure that everybody is held accountable to these laws, to these things. And that, yes, we do pull back the layers and we do equally do justice to all victims, and when the victims, or when those who are perpetrators or accused perpetrators or alleged perpetrators, when their rights are trampled on, when they are done wrong by those in authority, then we have to make sure that justice aids them as well. So in thinking about all of these things, yes, the prosecutor has a role, the public has a role, because jurors have a role. But Judge Donald and I also have that responsibility. And judges have to make sure that everybody is playing by a fair set of rules. And when, again, the prosecutor does have the power, and I think about what Professor Min said, and I think about what Mr. Robinson said, and I think about, cases where prosecutors, again, I was on the civil side at the U.S. Attorney's Office. Our job was to sort of recoup monies that the government had lost under the False Claims Act or something like this. But again, thinking about what prosecutors do. When I first came to the bench, Hurricane Katrina was about 5 years removed. But in trying to help the population, the government gave out debit cards to individuals. And so when I got to the bench, they were still prosecuting people for having abused those debit cards. Again, prosecutors having the awesome responsibility. So when a person who misused a debit card or falsely said that I'm in need of a debit card and stole money from the government in more than $1,000, that became a felony. A mother who was trying to get food for her children, now comes before me with a felony indictment when this matter could have been dealt with, I think, on the civil side. You charge her, you sue that person for that $1,000. You can even get the civil penalty up to $5,000. You can even get treble damages, another $3,000, and have that person pay back to the tune of $10,000 for every $1,000 misspent. Or you can charge her with a felony and move that single parent from the voting rolls of the public for the rest of her life. Those are the things that Jeffrey Robinson was talking about, that accept clause. Those are the things that Ian Min was talking about, how you're looking at this. And those are the things that Professor Davis was talking about. So I think judges have a responsibility to make sure that when these things are presented to them, that they have the right and the responsibility to say, Mr. Prosecutor, is this the best way to use the resources of the United States? I know it's in your discretion, but I need you to start thinking about how we're going to do for the next 10, 15, 20, 30 people. And those situations come up all the time. So judges have a role too to make sure that our criminal justice system works fair by all of us and works in the benefit of all of us, and that it works for all of us all the time. That's all I'm going to say at this point, and I certainly appreciate the opportunity, and thank you so much, Professor Judge Donald, Professor Donald, extraordinary.
Thank you, Judge Reeves. And I'm going to open it up to our panel, but I'm going to start with the first question of you, Judge Reeves. You have, in certain opinions that have been reported in the news, they've been so provocative and they've been held up as literal masterpieces, but you have, in your opinions, been a teacher. You have held up the injuries and the lives of some of the people to whom you referred today in the opinion by starting off describing the incident and saying this was not, I don't know if this was in Jameson or whatever, but you went through a catalog of many of these atrocities that occurred. Why is it so important for you to lift up these horrible incidents that have victimized people in the course of your current jurisprudence? What is your goal in doing that? But you have done it powerfully. I just want you to speak to that because we have some judges in the audience today also.
I think it's always important to, I guess what we've learned over the last couple of years is to, number one, say their names. These are living. Unfortunately, many of them are no longer living because of conduct done by law enforcement and done by people in authority. But it's important, number one, to say their names. These are not inanimate objects. Even criminal defendants, you should say their names in the courtroom. They are not defendants, and that's all that make them up. As Brian Stevens says, we're all better than the worst things that we've ever done. So we have to make sure that number one, we say their names. And what was so important for me in the Jameson case, which is a qualified immunity decision, that case sort of grew out of an judges are judges, and their decisions that they're writing, the things that they do, they act through the prism of their life experiences. And through this COVID, my family members decided that we would be getting together and talking to each other every month, the video, so that we could see the nieces and nephews. And what inspired the Jameson opinion was a conversation that grew out of that conversation that we had with our nieces and nephews after the George Floyd incident. I wanted to see what they were thinking about. Again, the prism of our life experiences. I've been stopped by the police before. I've gotten tickets, traffic tickets, speeding tickets. And Judge Donald, I can tell you this, in Mississippi, I've been treated great by law enforcement every time that I got, going back to when I was 18 years old. Got a ticket, everything was fine. Here's your ticket, gone about your way. Have never been mistreated. Been stopped in Illinois. Got a ticket, went on about my business. But my nieces and nephews were telling me stories. They a set of them live in Houston and another set live in Dallas. And we were talking. And as I'm thinking about this case that I'm writing, I'm hearing them. I'm hearing their stories. My niece tells me, who has 2 daughters of her own, 4 and 2, who's married to a young man whose father is in law enforcement here in Mississippi and has been for 30 years, who's former police chief. So her husband has grown up in law enforcement. She understands. She tells me how she's stopped there in Texas all the time, how she's stopped, how she's questioned about, how can you afford the car that you're driving? May I search your car? And she said, I'm on my way to Mississippi to see my family. My nephew up in Dallas, she's in Houston. My nephew in Dallas tells me how his wife is stopped more than one time in her own neighborhood. Why are you here? In her own neighborhood. In other words, show me your papers. And he tells me that they've been stopped as a group of family members before. And he said, how am I, they have me there they strip me of all my dignity and my manhood. And they do this to me in front of my family. How am I supposed to take this and accept this every time they stop me? They do that for the purpose of stripping me of my manhood before my family. So I do know that there are other experiences of people who have different experiences. And so I think it's important for us to elevate and put out there what the officer in the George Floyd thing told to the world. It's what Black people have been saying every day. Laquan McDonald was saying it and everybody else. But there, for that 8 minutes and 46 seconds, we all saw the whole thing, and there's no other narrative that can be told. So we have to elevate the truth of what happens out there on the street. And I think it's so important to say their names, to add history, to show a total context of what we what we see, what we hear, and what we have to rule on.
Mm-hmm. And for those listening, I know there's been something in the chat about the Jameson opinion to which I refer, but it's Jameson versus McClendon, and you can get the site if you just Google it. I don't have the site handy, but it is a must read, as Professor Davis just said. Thoughts and comments, reactions to any of your panelists now. Questions, thoughts, reactions, any of you. I don't have a question from the audience yet, but I know, Jeff, you were shaking your head profusely, or I'm not shaking your head, but you were nodding profusely as Judge Reed's talking. Can you sort of let us share in what you were thinking?
Well, I was just, as he was talking about relating to the experiences of his family, I was thinking about how Brian Stevenson always talks about proximity. And when things become proximate, then it becomes very, very, very difficult to ignore them. And that one of the things I was thinking is that if I had known what I know now about our history 30 years ago when I was practicing, and up until the time I stopped practicing when I went to the ACLU, I would have done things so much differently. There is this book written by William Burroughs called Naked Lunch, and the title is so provocative because he was always asked, what does it mean? And his response was, it's that moment when everyone has to look at what is really on the end of their fork. And I think the opinion that the judge wrote on qualified immunity was a naked lunch moment for American jurisprudence to look at what qualified immunity really is. It is the ability to strip people of their dignity in front of their families, maybe strip them of their lives, and not be held accountable for it. And so I just think that what the judge was saying kind of resonated across every single presentation. And that's why I was shaking my head so much, because it just feels like these are the kind of changes that will make judges at all levels of courts think, am I really prepared to sign off on this? Am I really prepared to put my name on this? And I think we are seeing examples in state courts and federal courts where judges are starting to say, I'm not willing to go this far anymore.
Absolutely. Thank you. Ellen Yarashevsky asked Professor Davis to please expand upon motion for justice and the role of the community.
Sure, thank you so much. And I've been busy putting in the chat the work of all my fellow panelists because it's amazing. Read Judge Reeves' opinion. I had to change my syllabus in criminal procedure at the last minute to include it, to have my students read.
It's powerful, yeah.
Powerful. And Jeff's Who We Are project, amazing, as well as Motion for Justice. So as I said before, it's a project to center race in prosecutorial decision-making for progressive prosecutors who really want to make a difference. And if you go there, they'll talk about action steps, and we don't have a lot of time, and I don't want to dominate. But there are things like, Jeff just talked about like getting proximate. Prosecutors need to go to a prison or jail and go in there and see what it's like. They need to have their assistants. All of them need to be required to do that so that they can understand the consequences of the decisions that they are making. Prosecutor offices need to collect data to determine whether or not they are creating these racial disparities and what the causes are so that they can fix those causes. They need to go to law schools, and law schools, I'll speak for the academy, needs to do a better job of teaching about race in the criminal legal system in every way. They need to decline and divert cases. They need to fix problems in the past. They need to set up not only wrongful conviction units, but sentence review units so that folks who were sent to prison for far too long, who are rotting in prison, you have people who are old and aging and dying in prison, who shouldn't have gotten the sentence they got in the first place and now need to be released. Prosecutors can make that happen. So I urge you to go to this site to see some of those examples of things that prosecutors can do, and I'll stop there. So
okay, so I'm going to give the last two questions to Professor Main and to Professor Creel. So Professor Main, have you had the occasion to present to any judicial groups on your paper, regarding the rules? And if so, what has the reaction been to that history?
No, but I want to. I absolutely want to.
Am I muted?
Part of this to me is engaging with the folks who have the power. And
Okay, are you muted? I can't.
I don't think so.
I can't hear anything.
I don't think I'm muted, but
No,
We can hear you.
Okay, I couldn't hear him, so let's keep talking.
okay. But no, I appreciate the question, and anyone in the audience, or yourself, Judge Donald, or Judge Reeves, any chance to be able to talk to your colleagues about, basically, in my mind, presiding over two separate and unequal courtrooms, I think, is part of the discussion. I think many of these arguments that we hear also from, say, the Department of Justice to defend the current structure actually, to me, plugs right into the narrative of Black criminality when they say, oh, we can't provide any kind of agency, like the ability to find facts and talk to witnesses, because they're dangerous. And then the other argument, of course, is perjury, and that they'll be able to distort the case's value with more facts. And first of all, after 7 years of representing elected officials and business people, I just, and by the way, on the civil side, they had talked about the idea on their discovery phase of the possibility of more facts equal perjury. They rejected that idea. They said the actual worst environment for perjury is when you don't have full disclosure, which is exactly how the criminal system operates right now. And I'll say one more thing. Not only do we keep prosecutors honest, we keep police honest. I don't know if any of you had the pleasure of taking a deposition. It's the one thing I miss from civil practice. But the fact of the matter that homicide detectives are not subject to them is something I cannot live with. And I think when we finally get to the idea that we get to question the motives and the investigation and what they did in a deposition environment, it is going to be a different ballgame. But anyway, I appreciate that, Judge Donald, and would certainly look forward to talking to other judges about this.
Thank you. Professor Creel, you talked about the Major Crimes Act, and you also talked about some of the derogatory and the slurs that have been actually in opinions and history regarding Native people. Is there anything going on now, not only to sort of combat some of the invisibility and increase people's awareness about these issues that negatively affect the humanity of Native people and how they are portrayed not only in history but today?
Not enough. No, there's not enough being done, Judge Donald. Thank you for asking that. The McGirt decision came out recently over the summer. Justice Gorsuch wrote an eloquent opinion identifying tribal land in Oklahoma as a reservation, never been disestablished for the Creek people. And it was resounded in Indian country as a positive Supreme Court decision, acknowledging both treaty, people, humanity, and all those things together. But there isn't enough being done. Even in the McGirt decision, the court cited United States versus Sandoval, which is a decision from New Mexico, and it's cited for a particular point. But if you read that decision, you can read some of the racist language. I believe it's footnote 6. That was talking about Pueblo people are Indian because they have negative attributes. They're lazy. They're not smart. They are warlike. And that was the definition of what an Indian was in the 1930s. And so when I had federal judges read this decision, they were in tears and in embarrassment of what the United States decision was relating, but there's not enough. We do trainings with the Administrative Office of the Court for defenders. There should be more federal judges that are Native American on the bench. And I really appreciate your willingness and to invite me and to listen. I just want to say that Judge Reeves said the prism of life experience, that judges, jurors, and others look at Native Americans through the prism of life experience. And that experience needs to be enriched with more than just seeing a Native American at the worst day of his life in federal court under the Major Crimes Act and under federal sentencing. And I would say federal prison needs to be abolished for Native Americans, and we should return to the restorative justice wisdom in Crow Dog.
Thank you very much. Let me thank all of our panelists. We don't have any more time today, but this has been incredible. We've got a lot not only to think about, but I think there have been calls to action here today. Thank you each. You are incredible, and you've been a benefit to not only our section and our profession, but to our world. Thank you so much. This concludes our session.